Grants Pass relies on camping laws to protect its public spaces. These generally applicable laws prohibit specific conduct and are essential to public health and safety. The Ninth Circuit tied cities' hands by constitutionalizing the policy debate over how to address growing encampments. It's holding that the Eighth Amendment bars Grants Pass from enforcing its camping laws is wrong for 3 reasons. First, the Cruel and Unusual Punishments Clause governs which punishments are permitted, not what conduct can be prohibited. Second, no precedent supports the Ninth Circuit's rule. Respondents in the United States abandon its reliance on Powell. Instead, they misread Robinson to bar any punishment for involuntary conduct that's linked to a status. But Robinson held only that states cannot outlaw the status of drug addiction. It made clear that they can prohibit conduct like drug use. This court should not rewrite Robinson 6 decades later. Third, the Ninth Circuit's approach has proven unworkable. The Eighth Amendment does not tell courts who is involuntarily homeless, what shelter is adequate, or what time, place, and manner regulations are allowed. But in 35 suits and counting, federal courts are now deciding everything from the exact size of campsites in San Rafael to the adequacy of empty beds at specific shelters, like the Gospel Rescue Mission in Grants Pass. And cities are struggling to apply arbitrary, shifting standards in the field. This court should reverse and end the Ninth Circuit's failed experiment, which has fueled the spread of encampments while harming those it purports to protect. I welcome the court's questions.
Do you consider these civil or criminal penalties?
They are both, Justice Thomas. There is criminal trespass and civil.
Is that involved in this case?
Yes, it is.
To what extent? I mean, has any of the petitioners, any of the parties here, been subject to criminal trespass?
Well, they are at issue in the case. The district court enjoined them, and yes, they do apply here. They are for recidivist offenses.
But which party has been held accountable for criminal trespass?
So here, none of the individuals who are currently in the case.
So what's involved in this case?
For Logan and Johnson, the civil penalty.
And so what, is it the anti-camping or what is it?
Yes, it is.
Okay, so that's civil or is it criminal?
The camping ordinance is civil, and then for repeat offenders, it's punishable by criminal
but
trespass.
we're not talking about repeat offenders right now, right?
That's correct.
So then, have we ever applied the Eighth Amendment to civil penalties?
Not the Cruel and Unusual Punishments Clause, no.